What's up, Amelia from Revenge Rewired here. Today's story, absolutely wild. Hit subscribe so you never miss one. The meeting was supposed to be routine. Mom had died 3 weeks earlier after a long decline from Alzheimer's disease, and her estate attorney, Vincent Carlisle, had called us both in to discuss the estate administration. But when I arrived at Carlisle and Partners that Thursday morning, my brother Derek was already there. Sitting in the conference room with a different attorney. I'd never met a younger man in an expensive suit who introduced himself as Todd Brennan. Before we discussed the will, Derek said, sliding a document across the table before I'd even fully sat down, "We need to address this." I picked up the papers. Durable power of attorney, dated March 2023. It granted Derek complete authority over all of Mom's financial affairs, medical decisions, and property. At the bottom was Mom's signature, or something that was supposed to be her signature. My hands went cold as I read through the scope of authority. Derek had given himself the power to access all bank accounts, sell property, manage investments, make gifts, and conduct any and all business on Mom's behalf. There was also a section I'd never seen in a standard POA clause stating that upon Mom's death, all assets would transfer directly to Derek as compensation for his caretaking services and financial management. "What is this?" I asked quietly. Derek leaned back in his chair with a satisfied expression. "Mom and I met with Todd in March of last year. She wanted to make sure her affairs were handled properly, and she wanted someone local to manage everything. Someone who was actually present in her life." The implication was clear. I'd moved to Seattle 4 years ago for my job at Boeing. I'd flown home every 6 weeks, called Mom twice a week, and sent money to help with her care expenses. But Derek lived 20 minutes from Mom's house, and he'd positioned himself as the devoted son while painting me as the absent daughter. "Mom had Alzheimer's," I said, keeping my voice level. "She was diagnosed in 2021. By March 2023, she wasn't capable of understanding complex legal documents." "Mom had good days and bad days," Derek replied smoothly. "Todd met with her on a good day. She understood exactly what she was signing." Todd Brennan nodded. "I spent over an hour with Mrs. Reyes. I asked her detailed questions to assess her capacity. She knew her name, the date, the purpose of the document, and the extent of her assets. She clearly articulated her wish to have Derek manage her affairs." Vincent Carlisle, Mom's longtime attorney, had been quiet through this exchange. Now he spoke up. "Derek, I have to express my concern. Your mother executed a comprehensive estate plan with me in 2019. She never mentioned wanting to change those arrangements. She never contacted me about a power of attorney beyond the standard medical POA she already had on file, which named both of you equally, which is exactly why she sought independent counsel." Derek said. "She knew you'd try to talk her out of it." "Derek, your mother and I had a relationship built on trust spanning 15 years. If she'd wanted to make changes, she would have discussed them with me." Vincent turned to Todd. "Mr. Brennan, I'd like to see your file notes from your consultation with Mrs. Reyes. It's highly unusual to grant such extensive posthumous transfer authority in a POA. That's between my client and me." Todd replied curtly. I looked at the signature again. Something was off. Mom's handwriting had deteriorated significantly in her final years. The Alzheimer's had affected her fine motor control. But this signature looked almost too neat. The letters were formed carefully, deliberately, without the tremor I'd seen in every birthday card and note she'd written to me since her diagnosis. "I'd like to contest this," I said. Derek's smile widened. "Of course you would. You can't stand that Mom trusted me to handle her affairs, not her absent daughter. She knew who really cared about her. She knew who visited her every week while you were off living your life in Seattle. Sending the occasional check like that made up for not being there." The accusation stung because there was a grain of truth in it. I had moved away. I had missed birthdays and holidays, but I'd made every decision I could to stay connected to Mom, and I'd been on the first flight home when her condition worsened in her final months. "The POA is valid," Todd said firmly. "Mrs. Reyes had capacity when she signed it. I witnessed that capacity. And the document was properly notarized and executed. You can contest it if you want, but you'll be wasting your money and your time." Vincent looked at me with an expression I couldn't quite read. "Sarah, if you're serious about contesting this, you'll need specialized counsel. This is beyond standard probate administration. You need someone who handles capacity challenges and financial exploitation cases." "I'm serious," I said. Derek stood, straightening his tie. Then, I'll see you in court. And when you lose, I'll make sure everyone knows you tried to override Mom's final wishes out of pure greed. I called Vincent from my car in the parking lot. You think it's fraudulent. I think your mother would never have excluded you from decision-making authority, he said carefully. I think the timing is suspicious. March 2023 was when her dementia was significantly progressing, and I think that posthumous transfer clause is legally questionable at best. What do I do? I'm sending you contact information for Jennifer Wu. She's an elder law attorney who specializes in undue influence and capacity cases. She's the best in Southern California. Call her today. Jennifer Wu's office was in downtown Los Angeles, in a building with views of the city stretching to the ocean. She was in her early 40s, with sharp eyes and the focused intensity of someone who'd built a career on details that others missed. Tell me about your mother's timeline, she said after I'd explained the situation. I pulled out the folder I'd been compiling. Mom was diagnosed with Alzheimer's in August 2021, early stage at that point, but declining. By March 2023, when Derek claimed she signed this POA, she was solidly in moderate stage dementia. What kind of symptoms? Memory loss. She'd forget conversations within minutes. Time confusion. She often didn't know what day or month it was. Trouble with complex tasks. Her neurologist noted she couldn't manage her medications anymore. Wandering. We installed locks on the doors because she walked out of the house at night several times, confused about where she was. Jennifer made notes. Who was her neurologist? Dr. Elizabeth Hammond at Huntington Medical Center. She'd been seeing her every 3 months since the diagnosis. Do you have access to those medical records? I'm listed as her HIPAA representative. I can request them. Do it today. I want every evaluation, every cognitive test, every doctor's note from 2021 through her death. If Dr. Hammond documented cognitive decline, that's our foundation. Jennifer leaned forward. Sarah, here's what you need to understand. A power of attorney requires the principal in this case, your mother, to have capacity at the time of signing. That means she needs to understand the nature and extent of her property, understand the scope of authority she's granting, and understand the consequences of her action. Mom couldn't even remember what she'd eaten for breakfast. By March 2023, I said quietly, then she couldn't have had capacity to execute a valid POA. But we need to prove it. Jennifer pulled up a document on her computer. Looking at the POA your brother presented, there are several red flags. First, the scope of authority is unusually broad. Most POAs do include posthumous transfer provisions because they terminate at death. Second, the language about caretaking compensation is concerning. Third, if your mother already had estate planning documents with Vincent Carlisle, why would she suddenly seek out a new attorney she'd never worked with? Because she didn't, I said. Derek sought out a new attorney, one who'd be willing to prepare a document without asking too many questions. That's my working theory too. But we need evidence. Jennifer opened a legal pad. Here's our strategy. First, we get Mom's complete medical records and establish her cognitive state in March 2023. Second, we depose Derek and his attorney about the circumstances of the signing. Third, we bring in a forensic document examiner to analyze the signature. Fourth, if needed, we find a neuropsychologist who can review the medical records and provide expert testimony about capacity. How long will this take? Depends on how hard Derek fights. But if the medical records are as clear as you say, we might be able to negotiate a settlement before trial. Most people don't want to commit perjury about a dementia patient's capacity when there's medical documentation proving otherwise. Jennifer looked at me directly. I need you to be prepared for something difficult. If we prove this POA is invalid, we're not just saying Derek made a mistake. We're saying he exploited a vulnerable adult with dementia. That's elder abuse. It can have criminal consequences. He's my brother, I said softly. He is also someone who potentially forged or coerced a legal document from a woman with Alzheimer's to steal nearly $1 million. Those things can both be true. Dr. Elizabeth Hammond's medical records arrived 2 weeks later, 143 pages documenting Mom's steady cognitive decline from 2021 through her death in September 2024. I sat in Jennifer's conference room as we went through them together. Dr. Hammond's notes were thorough and damning. August 2021, patient presents with increasing memory difficulties. Mini-mental state examination score, 24/30 diagnosis. Alzheimer's disease, early stage. Patient demonstrates insight into her condition and expresses concern about her future. November 2021. Cognitive decline progressing. MAMSAEN 22:30 partes. Patient now requires reminders for medications. Family reports increased confusion about dates and recent events. March 2022. MMSE 19/30. Patient demonstrates moderate memory impairment. Cannot recall visit from previous week. Struggles with complex financial tasks. Recommend increased supervision and support. September 2022. MMSE 16/30. Moderate stage. Alzheimer's confirmed. Patient disoriented to time, frequently confused about location. Family reports she no longer recognizes some relatives consistently. January 2023. MAMSAE 14:30 partes. Significant cognitive impairment. Patient cannot manage activities of daily living independently. Poor judgment, impaired reasoning. Would not recommend patient making significant legal or financial decisions without careful capacity evaluation. And then the critical entry, March 7, 2023. Patient accompanied by son for quarterly evaluation. MAMSE en 13:30 partes. Patient scored poorly on all domains: orientation, registration, attention, recall, language. When asked what day it is, patient stated Thursday, October. Today is Tuesday, March 7th. Patient could not recall my name despite seeing me for 18 months, could not explain what medications she takes or why. When asked about her living situation, patient became confused and upset. Son reports patient requires 24-hour supervision. In my professional opinion, patient lacks capacity to make complex decisions regarding finances, legal matters, or healthcare. Would strongly recommend guardian appointment for financial affairs. The POA Derek presented was dated March 12, 2023, 5 days after Dr. Hammond had explicitly documented that mom lacked capacity for exactly this type of decision. This is what we need, Jennifer said quietly. Dr. Hammond specifically stated your mother couldn't make complex legal decisions. 5 days later, she supposedly executed a sophisticated power of attorney with extensive authority and posthumous transfer provisions. No judge will find that credible. Derek was at that appointment, I noticed. He heard Dr. Hammond say mom lacked capacity, which makes what he did even worse. He knew she couldn't legally execute a POA, and he did it anyway. Jennifer pulled out her phone. I'm calling Dr. Hammond to see if she testify. Then we're filing an emergency petition to freeze the estate assets and invalidate the POA. The emergency hearing was set for 2 weeks later. In the meantime, Jennifer had been busy. She'd obtained statements from mom's home health aides, who reported that by March 2023, mom couldn't sign her name consistently and often didn't recognize family members. She'd pulled bank records showing Derek had already started moving money around before mom's death, transferring funds between accounts, writing himself checks for caretaking expenses, and withdrawing cash in amounts just under reporting thresholds. Most importantly, she'd hired Dr. Michael Torres, a forensic document examiner with 30 years of experience. Dr. Torres spent 3 hours examining the power of attorney in Todd Brennan's office under Jennifer's supervision. He photographed the signature under various lights, examined the paper and ink, and compared it to authenticated samples of mom's handwriting from various periods. His preliminary findings made Derek's fraud undeniable. The signature, purporting to be Eleanor Reyes, shows 3 distinct handwriting characteristics, Dr. Torres explained in Jennifer's conference room. He pulled up enlarged photographs on the screen. Look at the initial E in Eleanor. The formation shows a different pen angle and pressure than the rest of the first name. The R in Reyes has a completely different loop structure than appears in authenticated samples. And the baseline, the invisible line that handwriting sits on, shifts midway through the last name. What does that mean? I asked. It means at least 3 different attempts were made to create this signature. Someone tried to write Eleanor, didn't like how it looked, tried to fix it, then attempted Reyes and made additional corrections. This isn't how people sign their own names. This is how someone forges a signature with multiple hesitations, corrections, and attempts to replicate specific letter formations. He clicked to another image showing Mom's signatures from birthday cards she sent me in 2022 and 2023. Compare these authenticated signatures from the same time period. You can see the tremor in the pen strokes consistent with Alzheimer's-related motor control issues. You can see variations in letter size and spacing consistent with cognitive impairment. But you also see fluid, continuous strokes. She's signing her own name, so there's no hesitation, no correction, no conscious effort to form each letter correctly. The POA signature doesn't have any of that. Jennifer asked. Correct. The POA signature shows deliberate, careful letter formation without tremor, but with multiple starting and stopping points. Someone was trying to copy Eleanor Reyes's signature while also trying to make it look shaky enough to be consistent with her condition. They actually did too good a job on the letter formation and not good enough on the natural tremor. Dr. Torres pulled up a final image. I also found evidence of tracing. Under magnified infrared imaging, you can see faint pencil marks underneath the ink in several letters. Someone outlined the signature in pencil first, then traced over it in pen. My stomach turned. Derek practiced it. Someone did. And based on the handwriting analysis, that someone was attempting to disguise their own writing habits while replicating your mother's. I'll need authenticated samples from your brother to make a definitive comparison. But the evidence strongly suggests forgery. The emergency hearing was held in Judge Patricia Okonkwo's courtroom. She was a former elder law attorney herself before being appointed to the bench, and she had a reputation for being exceptionally protective of incapacitated adults. Jennifer filed a motion to invalidate the power of attorney and freeze all estate assets pending investigation. She attached Dr. Hammond's medical records, Dr. Torres's preliminary forensic report, statements from the home health aides, and a detailed brief outlining the legal standard for capacity. Todd Brennan filed an opposition claiming that Mom had capacity on the day of signing, that his assessment was sufficient, and that any challenge was simply a disgruntled heir trying to overturn valid estate planning. Derek sat at the defendant's table looking confident. He'd dressed carefully conservative suit, American flag pin, the picture of a responsible son. He'd even brought photo albums showing himself with Mom over the years, as if that proved anything about her capacity. In March 2023, Judge Okonkwo read through the filings with an increasingly grim expression. When she looked up, her first question was directed at Todd Brennan. Counselor, I've reviewed Dr. Hammond's records. On March 7, 2023, a board-certified neurologist with 18 years of experience examining Alzheimer's patients stated explicitly that Mrs. Reyes lacked capacity to make complex legal and financial decisions. You met with Mrs. Reyes 5 days later and determined she had capacity to execute a power of attorney. What assessment tools did you use? Todd straightened his shoulders. Your Honor, I conducted a thorough interview. I asked Mrs. Reyes about her understanding of the document, her assets, and her intentions. Did you administer any standardized capacity assessment? I relied on my professional judgment based on 15 years of practice. You're not a doctor, are you? No, Your Honor. But did you review any medical records before meeting with Mrs. Reyes? The family didn't provide any. Did you request them? Pause. No, Your Honor. Did you ask if Mrs. Reyes had been diagnosed with any cognitive impairments? Another pause. I asked about her general health. Judge Okonkwo made a note. Did Mrs. Reyes come to your office independently, or was she brought by someone? Her son Derek accompanied her. Did Derek remain in the room during your consultation? For part of it? Which part? Todd glanced at Derek. He was present during the initial discussion of Mrs. Reyes's wishes and the scope of authority she wanted to grant. So Derek Reyes was present when his mother was supposedly articulating her desire to give him complete control over her nearly $1 million estate. Yes, but I also met with Mrs. Reyes privately to confirm. For how long? Approximately 10 minutes. And in those 10 minutes, you determined that a woman with documented moderate stage Alzheimer's disease had the capacity to execute a complex power of attorney with unusual posthumous transfer provisions. Judge Okonkwo's tone made it clear what she thought of that assessment. Your Honor, Mrs. Reyes seemed lucid and oriented when I met with her. Jennifer stood. Your Honor, may I present Dr. Hammond's testimony? She's available via video conference. Proceed. Dr. Hammond appeared on the courtroom monitor, professional and composed in her office at Huntington Medical. She confirmed her credentials, her treatment relationship with Mom, and her findings. Dr. Hammond, in your professional opinion, would Mrs. Reyes have had capacity to execute a power of attorney on March 12, 2023? Jennifer asked. Absolutely not. Based on my evaluation just 5 days prior, Mrs. Reyes was significantly cognitively impaired. Her MMSE score of 13 indicates moderate to severe dementia. She was disoriented to time and place, had severely impaired memory, and could not manage basic activities of daily living. She would not have been able to understand the nature and extent of her assets, the legal consequences of granting power of attorney, or the scope of authority she was supposedly granting. Is there any possibility she might have had a good day where her capacity temporarily improved? No. Alzheimer's is a progressive disease. While patients may have fluctuations in alertness or mood, the underlying cognitive impairment doesn't come and go. A patient who scores 13 on the MMSE doesn't suddenly jump to 26 a few days later. The brain damage causing the impairment is permanent and worsening. If someone claimed Mrs. Reyes was lucid and oriented on March 12, 2023, what would you say? I would say that person either didn't understand the clinical definition of capacity, didn't properly assess the patient, or was misrepresenting the truth. Todd Brennan's face had gone red. Your Honor, I object to the implication. Your objection is noted, Judge Okonkwo said dryly. Ms. Wu, I'd like to hear from your document examiner. Dr. Torres presented his findings next. Walking through the forensic analysis with the same careful detail he'd shown me, he displayed the enlarged photographs, pointed out the multiple handwriting styles, explained the significance of the pencil tracing, and concluded that the signature was inconsistent with authentic signing and consistent with forgery. In your expert opinion, did Eleanor Reyes sign this document? Jennifer asked. No. In my expert opinion, someone attempted to forge her signature using a traced template and made multiple corrections in the process. This is not an authentic signature. Judge Okonkwo turned to Derek. Mr. Reyes, you were present when your mother supposedly signed this power of attorney. Derek stood. Yes, Your Honor. She signed it right in front of me and Mr. Brennan. You watched her sign it? Yes. The entire signature, without looking away. Derek hesitated. I believe so. It happened quickly. But you're certain she signed it? Yes, Your Honor. Judge Okonkwo pulled up Dr. Torres's photographs on the courtroom monitor. Then how do you explain the pencil tracing marks underneath the ink? How do you explain 3 different handwriting styles in a single signature? How do you explain the lack of tremor that appears in all of your mother's authenticated signatures from that time period? Derek's confidence was cracking. I don't know. Maybe the expert is wrong. Dr. Torres has testified in over 300 cases and has never had his methodology successfully challenged. I'm more inclined to believe his analysis than your convenient memory. She turned to Todd Brennan. Counselor, I'm going to ask you a direct question, and I expect a truthful answer. Did you actually witness Eleanor Reyes sign this document? The silence stretched for 5 seconds. 10, 15. Mr. Brennan, I asked you a question, Your Honor. The signature was executed in my presence. That's not what I asked. Did you watch Eleanor Reyes's hand holding a pen and forming the letters of her name on this document? Todd's voice had dropped to barely above a whisper. The signature was already on the document when I notarized it. The courtroom went completely silent. So you notarized a signature you didn't actually witness being created. Derek assured me his mother had just signed it, and you committed notary fraud. Judge Okonkwo's voice was ice. You falsely certified that you witnessed a signature you never saw executed. That's a criminal offense, Mr. Brennan. Todd Brennan had gone pale. Derek was staring at his attorney with an expression of pure panic. Here's my ruling, Judge Okonkwo said. The power of attorney dated March 12, 2023, is invalid. It was executed at a time when Eleanor Reyes lacked capacity, as documented by her treating neurologist. The signature appears to be forged based on forensic analysis, and the notarization is fraudulent by the attorney's own admission. She turned to Derek. Mr. Reyes, all assets that were transferred or accessed using this invalid POA must be returned to the estate immediately. Any funds you withdrew, any accounts you accessed, any property you transferred, all of it goes back. You have 72 hours to provide a complete accounting. Your Honor, I was just trying to help my mother. You exploited a vulnerable adult with dementia. You forged her signature or coerced her into signing something she couldn't understand. You violated her trust and attempted to steal your sister's inheritance. Judge Okonkwo's gaze was withering. I'm referring this matter to the District Attorney's Office for investigation of elder abuse, forgery, and fraud. I'm also referring Mr. Brennan to the State Bar for disciplinary proceedings and to the DA for notary fraud. She looked at me. Ms. Reyes, your mother's will from 2019 will govern the estate distribution. Vincent Carlisle will continue as the estate attorney. Any assets your brother hasn't already dissipated will be returned and divided according to your mother's actual wishes, the ones she expressed when she still had capacity. The DA's investigation revealed the full extent of Derek's scheme. In the 8 months between creating the fraudulent POA and Mom's death, he'd transferred $127,000 from her accounts to himself, sold her car and pocketed the $15,000 proceeds, and taken out a home equity line of credit against her house for $75,000. Phone records showed dozens of calls between Derek and Todd Brennan starting 2 months before the POA was supposedly signed. Text messages recovered from Todd's phone included exchanges like, "Need this done before her daughter visits, and make sure the language gives me full control." Most damning was a practice sheet found in Derek's home office during a search warrant execution page after page of Mom's signature, written over and over, with notes like "too shaky and loop wrong and try slower." Derek was arrested on October 15th and charged with elder abuse, forgery, grand theft, and financial exploitation of a dependent adult. Todd Brennan was charged with notary fraud, conspiracy to commit fraud, and professional misconduct. The trial was scheduled for the following spring, but Derek's attorney negotiated a plea deal. Derek pled guilty to felony elder abuse and grand theft. He was sentenced to 3 years in prison and ordered to repay every dollar he'd stolen, plus interest and legal fees. Todd Brennan lost his law license and received 18 months for his role in the fraud. The estate finally settled in January. I used part of it to establish the Eleanor Reyes Memorial Fund at the Alzheimer's Association, specifically supporting families dealing with financial exploitation of dementia patients. The rest went into a trust for my daughter's education and my own retirement. Vincent Carlisle called me after everything was finalized. "Your mother would be proud of you," he said. "A lot of people would have let this go rather than fight their own brother." "He counted on that," I said. "He thought I'd feel too guilty about living in Seattle to challenge him. He thought I'd believe I was the absent daughter who didn't deserve anything. But you weren't absent. You were working, living your life, and staying connected to your mother in the ways you could. Derek was the one who abused her trust." I thought about that a lot in the weeks that followed, about how Derek had weaponized my guilt about moving away, about how he'd used Mom's illness to position himself as the devoted caregiver while draining her accounts, about how close he'd come to getting away with it. If I hadn't requested Mom's medical records, if Dr. Hammond hadn't been so thorough in her documentation, if Dr. Torres hadn't found the pencil tracing under the ink, Derek would have inherited everything while I got nothing. But I had gotten the records. Dr. Hammond had documented everything. Dr. Torres had found the evidence. Mom's neurologist had spent 2 years carefully recording every evaluation, every cognitive test, every decline in capacity. Those records, 143 pages of clinical observations, proved that Mom couldn't have possibly understood what she was signing on March 12, 2023, and the forensic document examiner had spent just 20 minutes with a microscope and specialized lighting to expose the 3 different handwriting styles in Mom's signature, 20 minutes to prove what Derek had spent weeks planning and practicing. Sometimes justice isn't about dramatic courtroom moments or shocking revelations. Sometimes it's about medical professionals who document everything properly, forensic experts who know exactly what to look for, and having the courage to challenge a lie even when it comes from family. Mom's doctor knew she lacked capacity and wrote it down. The document examiner knew the signature was forged and proved it. And Derek learned that exploiting a vulnerable woman with Alzheimer's has consequences. The medical records took 2 years to compile. The forensic analysis took 20 minutes to complete. Together, they ensured that Mom's real wishes, the ones she'd expressed clearly when she still had her mind, were honored. And that's what mattered most.